All right, guys, thanks for joining me. I know it's a little bit late, but it's a good night to talk. There's some things that we want to talk about. I wanted to reiterate, I guess the strategy, because some people still are not very clear on the strategy. Listen, you guys contact me all the time. Every day, you guys contact me about something that you guys are dealing with, right? And one person might be dealing with rules of evidentiary procedure, irregularities in the evidence. Another person might have biased judge. Another one might have lies that's being told by the prosecutor or law enforcement. But nonetheless, you guys all have your individual issues. And you guys are asking me to come and help you with either a post-conviction relief or your actual offense. And what I want us to understand here is that if we can identify one particular instance in which government has breached your constitutional rights, then from that moment forward, everything that government does is going to be unconstitutional. So again, I want you guys to understand here that if the arrest is unconstitutional, because they did not have the proper paperwork in accordance with the Constitution to perform that arrest, then everything after that arrest is unconstitutional. Guys, 99% of the people that are arrested here in America did not either, one, have a grand jury indictment because they live in a state that doesn't conduct a grand jury, such as Connecticut, Pennsylvania, Michigan, Washington, or they live in a state that has an equal protection issue, right, where they permit the prosecuting attorney to charge by information or indictment by their discretion. That is still unconstitutional, such as Oklahoma, such as Florida, such as Texas, such as Alabama, such as California. These are states that are permitting their prosecuting attorney to decide who gets a constitutional right and who does not. And that is a direct violation of the Equal Protection Clause of the 14th Amendment. So my point here, guys, is that the reason why I don't respond to you, right? The reason why I'm not coming out there and fighting your battles at the states is because we don't need to. We don't need to do an individual petition. We don't need to do an individual post-conviction relief. All we got to do is every single one of us come to the point where we all are getting our rights violated, and that's the arrest. That's the arrest. Now let's break it down here, okay? You see, with the way that the attorneys are doing it, they want to make money. Sorry, guys. They want to make money, right? So they're going to charge you $20,000, $30,000 for a post-conviction relief, for an appeal. And they're going to do it one at a time, one at a time. And you're going to spend $30,000 on something that you've got about a 3% chance of winning, So you're gonna spend that money on one single appeal. But what I'm offering to you guys right now is not one at a time. You're not going to pay me $30,000. You guys can pay me $1. And there's 2.9 million of you, right? And you think I can get this job done with $2.9 million? Absolutely. You guys can save your money, right? Sorry about that dog, guys. You guys can save your money and not pay an attorney to do a post-conviction relief for you, because what's happening there is that you guys want to say to me that this is implausible, right? That they'll never do this because it's so big. And you know what? The truth is that the size of this issue, it doesn't weaken the argument. It actually strengthens it. It strengthens it dramatically. Because when you guys are coming with a post-conviction relief, that's one single issue. One single person coming up with one single issue. And so you don't have a whole lot of power. You don't have a whole lot of noise, right? You're not able to amplify an issue because you're talking about one single issue. You see, these prosecutors, these attorneys, they want you off by yourself, arguing your own issue. They want you talking about the evidentiary procedures. They want you to talk about the biased judge or the lies from the prosecutor. They want you to do that because that puts you by yourself. We got strength in numbers. We have 2.9 million people currently incarcerated in prison. Every single one of them can talk about we have 2.9 million people that are currently incarcerated. Every single one of those people can talk about the arrest. Every one of them. We have 10 million people pre and post conviction. Every single one of them can talk about their unconstitutional arrest. Every one of them. Because every single one of you were affected in the same way as a result of the state's failure to arrest you in a lawful constitutional manner. And you see what that does then is that doesn't have us off by ourselves, arguing our own issue where we're only have the power of one. That puts 10 million people talking about one single issue. And now we got magnification on that issue. Now the Supreme Court will never shut that back up. Once we shine light on it and we put the power on it, then as of that moment, that will never, ever, ever be made silent again. You see, I can continue to run around the country begging that we can get heard, right, on this issue that is valid. There's no denying that this is valid, you guys. No denying it. But we're not being heard. They don't want to hear us because they know that the moment that they hear us, then they have to address it. And you guys, the Supreme Court of the United States, they will side with this. They have to. Because the only reason why the Supreme Court exists is because of the Constitution. It's the only reason why it exists. Article 3 is the only reason why the judicial branch has any existence whatsoever. Those 9 justices in Washington, D.C., they get their power from Article 3. They don't want to hear this because it's going to have a dramatic impact on their business operations. And they don't want that to happen. And they're going to do everything in their power to prevent from hearing this. But if they hear it, they will have to side with it. Because those justices do not want to give up their power. They do not want to give up their institution. And if they don't side with Article 3 and its supremacy of Article 3 and demand that every single court within the purview of the United States of America, within their purview, obey the edict that they put out, then they don't exist anymore. Washington, D.C. doesn't exist anymore. You see, this is the same argument that I have for Senator Mark Wayne. I just did. He was the last senator I talked to. And I told him, if you're going to say to me that when Oklahoma enacts its own alternative legislation that amends and deprives his own constituents of the very rights that are contained within the Bill of Rights, if you're not willing to stand up and defend Article 1 and its supremacy and say to the state of Oklahoma, you don't get to do that because you can't amend the Constitution of the United States. If you don't do that, then you don't exist anymore. You're not the center of anything. So, each one of these guys, the problem is that they don't have a backbone. They're just a bunch of pussies, guys. These senators, congressmen, they're nothing, man. They don't even have the integrity or the character or the courage to step up and preserve their job. And if that's the case, great. Let's shut Washington, D.C. down. Because if the president isn't willing to stand up and defend Article 2, which is what creates him, he doesn't exist anymore. You see, each one of these branches, whether it's the legislative branch, the executive branch, or the judicial branch, if they don't side with this, and trust me, they're going to do everything in their power to not hear it, to pretend like they don't hear it, because they don't want to have to make this decision. They don't want to have to do it. But if we bring it to the point where they have to hear it, because there's so much noise on it, they're going to side with this. They're going to side with it. They have to side with the Constitution, or their institution goes away. All 3 of them. Legislative branch will side with this because they have to. If the Constitution of the United States says something and someone does something different, that's unconstitutional. Guys, I've been trying to tell you since the day I started coming out here, I've been trying to explain to you that one of the things that I was taught in the school that I went to, George Washington University, the master's degree that I got in the law that I got, not procedural law, not administrative law, substantive law, what we were taught was anything that is not the Constitution is unconstitutional. Let that sink in for a moment, guys. Anything that is not the Constitution is unconstitutional simply by virtue of the fact that it's not the Constitution. That's why I say that the highest form of law is the Constitution. And the military philosophy, the military strategy is that whoever holds high ground has got a superior tactical capability. So if the Constitution is the highest form of law, then you get up into that high ground. You get up in that superior tactical capability and you don't come down off of it. When they try to draw you down into the weeds, when they try to draw you down into case law, you say, no, I'm not going to come down there. I'm going to stay in my elevated position. I'm going to stick with the Constitution because I'm going to draw you up to my level. And when you draw the judges up to your level, at the highest level, the Constitution, those judges can't fight at our level. They need you down at their level, arguing a bunch of stuff that isn't even constitutional. You don't have to argue with them on their merits of the argument. Anything that's not constitutional is unconstitutional. And it's unconstitutional not from the moment it was deemed such, but rather from the moment it was created, as it was never even created at all. You see, if we want to get the Constitution back in its foundation, where it's supposed to be, because I think that that's what we're all trying to do. We want that Constitution back in its place, at the foundation. Well, the problem is that right now, they constructed this temple of justice upon the foundation of judge-made rulings and executive orders. The whole foundation is judge-made rulings and executive orders. The top is the Constitution, because the Constitution is the opposite of a judge-made ruling. So, if the Constitution was meant to be the foundation and everybody was to abide by it, all the rulings of the judges were to be consistent with it, because if they aren't, then they would be unconstitutional. And we know that judges are tethered to the Constitution because of their oath, their affirmation, and the supremacy clause. Then that means that if the judges go to a judge-made ruling, to what they call case law, to determine whether or not your rights have been violated, then they're going to the object different from what their fidelity is bound. They have to go to the Constitution to determine whether or not your rights have been violated, not to the flawed decision of the man that came before them, or the flawed decision of the man that came before them. But we're under this belief here in America that judges make rulings, and those rulings are called case law, and we rely upon that case law to determine the future of the law. And that's not what we created. That's what England created, because in England, the king makes the laws. And he grants his agents, the judges, the ability to speak the law because he can. And so therefore, judges in England do create law. What they say is law because the king permits them to do it. But here in America, we don't have a king. Here in America, the people of the United States, we create the laws. We delegated that to ourselves. We did not delegate that to any other branch of government. The judicial branch can only create rulings, and those rulings must be consistent with positive law because the judges are tethered to positive law. They don't get to create law. So when you create a ruling and then you call it law, well, that's something that was created by a branch of government that has no authority to create law. And now we have an unconstitutional law because the judicial branch doesn't have authority to create law. Now, on the flip side, the executive branch doesn't have the authority to create law either, such as they were doing as a result of Chevron. If the executive branch is not clear on what the law requires, then previously what they were doing was they would go out and write their policy based upon the ambiguity, and they would clarify it based upon their policy, and then they would go out and they would enforce the policy under Chevron. Well, we know that Chevron is now overturned, right? And that means that executive branch, you don't get to create law. You create orders, executive orders, and those orders only affect those that can be ordered. The president can't order the people because we are the sovereign. We're the ones that create the law. We're in charge. We're in the driver's seat, not the president. He's our servant. So the president makes orders, and he can only order those that work for him, right? It's the only people that can be ordered. On the judicial side, they make rulings, and the only people that are ruled are those that work for them. The judges in every state are agents of the United States Supreme Court. I'm tired of hearing this bullshit about how there's states' rights and there's a separation between the two. There is no separation between the two. And we know that from the Supremacy Clause, where it says the judges in every state shall be bound thereby anything in the Constitution or laws of any states contrary, notwithstanding. You see, these states are not sovereign. A sovereign state is defined as a state that is complete in itself, not subject to a higher government's laws. A non-sovereign state is a state not complete in itself, subject to a higher government's laws. So when the states joined the Union, they gave up their sovereignty to subject themselves to the supremacy of the United States Constitution. Every single state constitution within the first article declares that the United States Constitution is the supreme law of the land. Guys, they're trying to change our reality right now because they don't want to have to address these fucking lies that they put into place. They don't want to have an impact to their business operations, and that's what this whole thing is about. There is no dual sovereignty. You do not have a state citizenship at the same time that you have a national citizenship. You can't be in the middle of a state adjudication and be deprived of the very rights that you're guaranteed by the Constitution of the United States of America, because the only reason why a state justice system has any authority to operate is because of the sovereignty of the United States of America. If they want to call it a corporation, call it a fucking corporation. But that would mean that you have corporate charters, and that charter dictates the satellite offices. The only reason why a regional government has the authority to have a justice system is because they're operating under the licensing authority of the central government's justice system. States do not have sovereignty. They are subject to the Constitution of the United States of America. And if we don't stand up and address this and their ignorance and the shit that they're trying to do, we're not going to have a country anymore. That's what I'm fighting for. That's what I've been fighting for 9 years. I just want people to understand that if we don't defend the Constitution of the United States, we lose the United States. We lose it. But we can't. And that's why we can't give up either. You know, I'm so tired, guys. I'm tired of not having a way to get around. I'm tired of not having food. I'm tired of not having money. I'm tired of not being a fucking normal person. I can't have a wife. I can't have kids. I can't even have a fucking relationship because I'm committed to this. Because this is, and you know what? When you rob a man of all he has, you made a man with nothing to lose. I'm tired, you guys. I'm tired. We're all tired. But we can't give up. Because the moment that we give up on this is the moment that we've lost this country. We can't permit those that are ignorant, right, that are focused on financial gain or focused on business sustainability and continued operations. We can't permit them to let us lose this hope. Because they don't want to lose this country either. And I'm telling you right now that Senator Mark Wayne, he doesn't want to lose America. He's just too big of a pussy to fucking deal with it, right? He doesn't have the backbone to step up and say, you know what? I'm going to stand for the Constitution, right? That's not an integral person. That's not a person with good character. That's not even a leader, right? You know, and that's why I've said for a year now is that this issue of criminality, the way we're trying to solve it from the bottom up, where we go out and arrest the people for the crimes they commit, it's never going to work. Never. It will never work. And this isn't rocket science, guys. This is simple common sense. It will never work going out and arresting the people of the United States for the crimes that they commit, because if our country is being led by criminals, and remember, the definition of a criminal is simply one that transgresses the law. That's the definition. If you transgress the law, you are, by the very definition, a criminal. It doesn't matter if that law is the Constitution of the United States or that law is a state statute. If you transgress the law, you are a criminal. So if our country is being led by criminals, people that are refusing to recognize and enforce the body of laws governing this nation after taking an oath to do so, which crime do we want to get them on? Perjury, treason, misprision, extortion, any number of different crimes they are automatically guilty of the moment that they fail to fulfill the obligations that are constitutionally codified once they've made a promise to do so. If our country is being led by criminals, and every single one of these guys are criminals, I've shown it, guys. I've served them with the fucking notices showing them that all of your agents are all committing crimes. We've given them opportunity to be able to cure this issue and to address it, and they've chosen to do business as normal and not hear it. Well, it doesn't matter if you don't hear it. You've been made aware. And just because you ignore it doesn't make it go away. It actually makes you complicit in it due to your complacency, because every one of them have the ability to do something about this. And remember, the law is a criminal conspiracy. Any person who, having knowledge of any of the wrongs conspire to be done, and who have the power to prevent or aid in the prevention of the commission of same, neglects or refuses to do so, may be joined as defendants in the action. We've shown over the summer, we've shown 37 state attorney generals and 37 state Supreme Courts that every single one of their agents across their states are committing crimes. Crimes that, as prescribed by law, are punishable by death. And they're doing it multiple times every single day because they're being permitted to bridge their obligations of the Constitution. Now, individually, myself included, when you take an oath to the Constitution, you have an obligation to make sure that the power that you exercise is consistent with your authority. I can't act outside of what I'm lawfully delegated authority to do. Now, when I stepped up and I realized that there were people that were warring against the Constitution domestically, I actually had a statutory obligation to do this, to step up, to self-execute the oath that I took, because I have an honorable discharge and I could be recalled into active service at any moment. Therefore, that oath is perpetual, it's binding, and it's self-executing. I do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic. When I encounter a judge that is refusing to recognize and enforce the Constitution of the United States, and I warn him multiple times, I'm talking about you, Mr. Alexander, the hell's your last name? Ruff. When I inform you that you're bridging the obligations that you have, and you choose to continue to do it, you are now knowingly and willingly engaging in a criminal act. Right? You were warned 4 times extra that you're breaking law. I told you. You know that's a crime, and you said I can do that. State of Washington gives me that right. I told you no, it doesn't. You don't have the right to break the law. And I said that I demand that I have evidence that I demand that this court hears, and any attempt to prevent this evidence from coming forth is a crime. And you said you will not present that evidence. You were knowledgeable. You showed your mens rea within that particular argument that we had there, the debate, in front of a jury and in front of 14 other people. You did this. So there is no immunity, guys, from a criminal act. No one is immune. Absolute immunity, judicial immunity, prosecutorial immunity, every single one of them is only immunity from civil liability. Not criminal liability, civil liability. And the reason why is because you don't sue the agent for the things that the agent does to deprive you of rights or whatever damages that occurs, because he's only doing what his master told him to do. That judge is only doing what the state laws tell him to do. But he's not smart enough to realize that the state laws don't matter. If the state laws are in conflict with the Constitution of the United States, you must obey the Constitution of the United States, because even the state constitutions within the first article have all put themselves in subjection to the Constitution of the United States of America. Every single one of them. In Washington State, it's Article 1, Section 2. United States Constitution is the supreme law of the land. That means that the state constitution is nothing That means that you must go to the higher form of law and not rely upon the lower form of law. You see, an abuse of discretion, according to the Circuit Court Handbook, you guys can all go and get it, look up abuse of discretion. There's a two-part test to determine abuse of discretion, according to the United States Circuit Court. The first test is, did the judge render a decision? Did he apply the incorrect test? Well, this is not what we're referring to. But the second part is any erroneous view of the law is an automatic abuse of discretion. Any erroneous view of the law is an automatic abuse of discretion. Now, let me tell you what an erroneous view of the law is. That in the judge's legal contemplation, that a state law that permits him to deprive you of a right guaranteed by the Constitution of the United States is in legal contemplation superior to the provisions and guarantees of the fundamental rights contained within the Constitution of the United States. That would be an obvious erroneous view of the law. Therefore, an automatic abuse of discretion has occurred. You see, the judges have to look at the hierarchy of law. They have to know that the Constitution is the supreme law. That's what you go to. And anything that's in conflict with that is unconstitutional. So if you're going to go to a state statute that says you can charge by information, not by indictment, but the Constitution of the United States says you must charge by indictment, then which law is supreme? Well, in the judge's legal contemplation, he's saying the state law is supreme. But state laws aren't supreme. State laws are in subjection to the Constitution of the United States. Guys, we are going to win this if you guys will get behind this. We need the noise now. We need you guys to help me make so much fucking noise that goddamn 9 justices in DC, that they're going to get so scared of us returning to DC with these 500,000 criminal affidavits. They're going to be so scared that they're going to sign this writ before I even fucking get there. And we're going to win without even a fight. Because if we get there with these 500,000 criminal affidavits, if we get to DC and they haven't taken action, then it's going to be too late for them. And they're going to be heading to the gallows. And you guys know this. You know this. Because those 9 justices, they're not going to be able to tell, because think about it. They don't have the backbone to tell the people of the United States about the shit that they did. You think they're going to have the guts to tell the people of the United States that they are not going to follow the Constitution? And that, hey, everybody, we don't rely upon the Constitution anymore. It doesn't exist. We're going to go off of judgment. Do you think that the people of the United States is going to permit them to even make it home that night? No, man. Because every one of us are going to know that they're traitors at that point. Traitors. They've created seditious laws, right? Sedition is the speaking or writing of words, such as law established, in order to cause disaffection to the Constitution, to procure its alteration in an other than lawful manner. If you attempt to change the Constitution in any way other than what is prescribed within the special amendment procedure of Article 6 or Article 5, you have just committed a seditious act. Sedition is altering the Constitution in other than lawful manner. So that despicable institution that we have to call honorable, those assholes that fucking are just a bunch of liars, walk around in these long black robes, guys, these guys knew that in 1833, the Marshall Court decided that they were going to suspend the Constitution in the ruling Barron versus Baltimore, and they were going to remove the fundamental rights that are guaranteed to the people by saying, oh, the states, they don't have to follow that. That's only restriction against the federal government, not the states. And you guys understand that as of that moment, none of the Bill of Rights were guaranteed to anyone. None of them. So this is 1833. Remember, the people of the United States, we won our liberty. We declared our liberty in 1776. But then 1781, we won our independence. We won our liberty, right? We were under the belief that, hey, I got the freedom to be able to speak, right? Whatever words I see fit, right? And I have the freedom to be able to worship however way I want to, against any God that I want to. That those are my freedoms. I get to develop that conscience and develop myself. So the whole point here is that from 1776, when we declare our independence, we declare our right and freedom to be able to worship how we want, speak how we want. It wasn't until 1925 that anyone was protected by the freedom of speech. That's a fact. Because the Marshall Court decided in 1833 that they're not going to give that right to the people because the states aren't required to follow the Constitution. Guys, he did that for a very specific reason, right? He did that because Barron versus Baltimore in 1833 came out in February. The ruling was in February. In August, they established the first national bank. Guys, we know that this is a banking system. We know it's an accounting system. We know that, right? We know this is a commercial. We know that every single crime has a quantitative amount that is assigned to it. For instance, murder is $25,000 because the courts of record can only do a maximum of $25,000. So the worst crime possible would be murder, and therefore, that's how much a murder costs. And so if you were to walk in there with a bond to be able to cover your $25,000 and you were to lose the debate, you attach to the bond. The only reason why you go to prison is because you don't have the money to pay for the cost of that crime. And you have to sell yourself into slavery to settle the debt, and you're forced into involuntary servitude for the direct benefit of the state. But the thing is that the First National Bank, August, gets established. Now, why did Marshall have to put into place Barron versus Baltimore? Because the central government, they knew, particularly the Supreme Court, they knew what that bank was going to do. They knew that this was all a debt-based system. They knew that this was all commercial. They knew that they were going to profit off these illegal acts from the fucking beginning of all this. And they're going to do it under the auspice of justice. We're going to tell you that, this is justice. No, justice is simply a term that was created by slave owners in order to preserve and protect their property. There is no justice. Read Plato's book, The Republic. He will tell you that justice is not good or bad. It's actually a compromise between two evils. Because good is evil, obviously. What we call good here in America is not all that good, right? Because they are killing people with absolute impunity, right? 139 of the 1,500 people that we put to death here in America were innocent after they were murdered. Proven to be innocent. That's not good. That's evil. They're locking people up that are innocent. And then they say, it's the system. That's an acceptable deviance. This is what they're doing. That's not good. That's evil. And if good is committing evil, is it good? No, because good is incapable of producing such an act. Only evil can produce evil. So what Plato was trying to get at is that those who serve evil, right? That those that fight evil, they need to be careful that they themselves don't become evil. Because if all that they see every day is evil, then eventually they're going to come to believe that that's all that exists. And so just as Nietzsche said, those who fight monsters should see to it in the process they don't become a monster. This system has become the monster. And honestly, I think it probably always was. But nonetheless, it didn't have to be. Because we could have had a just system built upon just principles of all men being equal. But our founders failed us, guys. They failed us, man. Because our founders, George Washington, Thomas Jefferson, James Madison, all these men that we look up to and we call honorable because they were so fucking honorable in what they did, because they started a nation where all men are equal, because the laws apply equally to all people. No, they didn't. No, those were their words, but their actions were something completely different. That means that they're a liar. And yet we don't see this. We're still calling George Washington the greatest human character to have ever lived. That's not good human character. He was saying that he believed in all men being equal, but when it came right down to it, he didn't want to give up the business. He didn't want to give up his slaves and make all men equal. That's not a man that believes that all men are equal. And when you present the argument to me and say, that's because they didn't see them as people, that's not true. Don't buy into that bullshit, because when George Washington died, he didn't just pass his property down to his grandson. No, he released his slaves, let them go, because he only needed them as long as they were profitable to him. He saw them as people.
No,
Because if he saw him as property, he would have just passed him down to his grandson. So my point here is that we started a business. It's a business. It's a business that's based upon the industry of slavery. Because justice is nothing more than terms created by slave owners to preserve and protect their property. We know that from a number of different sources, such as the Fugitive Slave Act. A fugitive is a slave, and a slave is a fugitive. We know that from the 13th Amendment, the very amendment that was adopted and ratified by the people in 1865 after 1 million people died in a war fighting against the inequality of all men, right? We adopted it and we believed it, that it abolished slavery, but it did nothing of the sort. Not only does it permit slavery, but it codified the legality of it within our own foundational law, the very law that guarantees the freedom of all men. Has the ability to enslave at the same time, because it doesn't say you can't have slavery. It says neither slavery nor involuntary servitude shall exist except as punishment for crime. And the moment that you say except, it means that you can have slavery. We just call it justice here in America. So we took something, we retitled it something different. We changed it from a private institution to a public institution. And then we said, you know what? It doesn't exist, but it does. That's why mass incarceration exists here in America. That's what's led to 800% increase in the prison population in 30 years. That's why America imprisons at a rate of 16 times more than the next closest industrialized nation. That's why we have 5% of the world's human population, but 26% of the world's prison population. Because we take the weak and the vulnerable in our society and we force them into an involuntary servitude for a for-profit state-run business for the direct benefit of the state. The state is the fucking slave owner. Slave owner. And how does that slave owner get its power? From the fucking slave traders called the judges. This is their industry. This is their business. And you know what? When you look at the attorneys as well, because you guys are calling me and you're like, oh, I would love for you to come and help. But if you're not going to do it, then I'm just going to go pay this attorney $20,000 and sell my card. Listen to me, guys. If you're going to turn to an attorney to try to solve your problems, just remember, they're incapable of such an act. This is their business. They only know how to make a person into a criminal because they were only trained in the laws that remove freedom. They are in the business of slavery. Because if the 13th Amendment made synonymous the term criminal and slave, they mean the same thing. According to America and American laws, a criminal is a slave and a slave is a criminal. Because you can be enslaved as a result of punishment for a crime. So if that's true, then that means that a person that's trained to make a person into a criminal is trained to make a person into a slave. They have degrees that they've been taught to remove freedom. They don't rely upon the Constitution because they're administrative officers of the court. Their duty isn't to the client, their duty is to the judicial machinery because they've been trained to follow judges. That's what administrative law is. When the administrative branch creates a law or a ruling and then erroneously call it law, that's administrative law. Judges don't create law, but when you call a ruling law, that is administrative law. That's why Gorsuch, right, last November, that's why he wrote the judicial notice to every single federal judge and said that most of the people in prison here in America are there illegally and unconstitutionally because the states, the courts are proceeding under administrative law and not common law. He wrote it. You guys can read it. It's available. He wrote it in his book even, Overturned or Overruled. If you guys haven't read it, go read it. I mean, he made all kinds of incriminating statements within that book. I mean, fuck, you know, he admitted all these crimes that the Supreme Court's doing. And remember, when one member of the court admits crimes, every member of the conspiracy has admitted crimes. We already got the Supreme Court. We've already won this, you guys. We just have to make them hear it. We just have to make them concede. That's it. But Gorsuch said in that memo, November 11th, he said that most of the people in prison here in America are there illegally and unconstitutionally because the courts are proceeding under administrative law and not common law. We'll come back to this in one moment, guys. I don't want to talk about Trump quite yet because I'm going to alienate some people here and I don't want to. I'm sorry, guys, but we're going to have to talk about what's going on because I don't want you guys to be fooled. I don't want you. You guys are right now. You guys are being fooled. It's a diversion, right? I keep talking about diversionary tactics, right? That's what our government does. It creates a diversion. It gets you looking over here so you don't realize that government's over here robbing you fucking blind. We're gonna talk about that in a moment, right? We're gonna come back to Trump, right? I'm not ready for that. But Gorsuch said that the courts are proceeding under administrative law and not common law. So when the Supreme Court of the United States, right, when they create a ruling and then they call it law, and then they say, here's the law, and the law now says you don't have to have an indictment, that Supreme Court amended the Constitution in an other than lawful manner. Supreme Court doesn't get to amend the Constitution. Only the people can do that. Once again, remember, sedition is the speaking or writing words, such as law established, in order to cause disaffection to the Constitution to procure its alteration in an other than lawful manner. In 1887, when Supreme Court Chief Justice Waite made the decision in Hurtado versus California to rely upon the state of California's inferior state statute to deprive people of the United States of the rights that are guaranteed by the Constitution by removing the indictment by grand jury requirement, he amended the Constitution in an other than lawful manner. That was sedition, done by traitors to the country. The Supreme Court has no authority to amend the Constitution, and certainly not to remove an obligation that they have. How can those that are bound to obey the obligation decide to not do the obligation? No person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. Who makes the decision to hold someone over? Well, that would be the judge. That would be the judicial branch. Yes, the prosecutor can bring the incorrect charging instrument, but it's the judge that commits the crime. It's the judge that establishes the conspiracy, because no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. The prosecutor can bring the incorrect charging instrument, but it is the judge's job to make sure that the proper documentation is in place before you hold someone over. And if the judge makes the decision to hold them over, the judge committed the crime. Deprivation of rights under color of law. And he established the conspiracy by and between himself and the prosecutor when the prosecutor brought the incorrect charging instrument, and now the prosecutor is also guilty of both crimes. They've established a conspiracy. When that judge hands it off to an officer and tells the officer to go out and make the arrest, that officer is also limited in his ability to be able to take action. If he abuses his discretionary authority, his delegated authority, and goes and performs an arrest when he doesn't have the proper documentation, that doesn't negate his liability. No, he's still depriving you of a right under color of law without authority because he was negligent in making sure that the proper documentation was in place. And now he's a member of the conspiracy. Now he's committing that crime. And remember, if anyone is taken against their will and held in a place and told, if you don't pay, we're gonna keep you here, that's called kidnapping. And it's a federal offense, 1201, because you can never, ever, ever hold someone over for ransom, because if you do, that will always be a federal offense. Always. So if you're gonna arrest me, and you're going to take me against my will, and you're going to lock me in a fucking box, and then you're going to say to me, if I don't pay you $500, you're not going to let me go. Or if I don't sign my house over to you, you're not going to. That's called extortion, man. The mob did that same shit. You know, fuck, they do the same shit down in fucking Brazil, down in Colombia, and we're in America. But our own leaders do the same fucking thing. Because they're criminals. So again, this issue of criminality, the way we're trying to solve it from the bottom up, it's never going to work. You can't solve the issue of criminality from the bottom up, because criminality is not a matter of punishment. It's not a matter. It's aberrant behavior, and the way that you correct aberrant behavior is by leading, by teaching, right? By good leadership. If my wife and I, if we create an abusive environment because we're abusive, we will produce abusive children because they're a product of their environment. And if my son is abusive because I'm abusive, then can I go to my son and say, oh, I'm now going to punish you for your abuse because I'm not looking at myself, right? I mean, wouldn't the father need to say, you know what, son, I'm sorry that I led you in the wrong direction. I'm sorry that I failed you, right? And I'm going to step up and I'm going to lead you in the right direction because I want you to go in the right way. I want to lead you in a different. So why would it not be the same for the leaders of this country? If they want to create a criminal environment by buying, selling, and manufacturing drugs, and bringing those drugs into, the low-income communities through their drug task forces, through their CIs, and they're going to buy and sell, manufacture drugs within these environments so that people will come in and break the law within the environment that they created. And they're going to say, oh, well, now you're under arrest. You're under arrest now. We're going to send you off to prison. No, that's not how that works. But for your crime, government, there wouldn't be fucking crime. You don't get to create a criminal environment committing crimes and then hold the people accountable for the crimes that were committed in the environment that you created. That's an inchoate crime. But for your crimes, there wouldn't be crime. When government acts unlawfully, everything it produces is unlawful. That's why what we're doing here is we're drawing a line in the sand. We've identified the constitutional parameters. We've identified that all of these agents have to obey the Constitution. And what I've done is I've drawn a line in the sand. Right? Here's the line. This is what the law is. We're clearly standing on the lawful side because the Constitution is our law. That's our weapon, not yours, government. So this is what the Constitution says. These are what your obligations are. And you're clearly operating outside of those obligations. Clearly. Because when the Constitution says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, and you say to me there is no indictment by a grand jury, I'm going to say to you that's unconstitutional. You're on the unlawful side of the law. When government functions outside of the law, what it produces is lawless. Because there can't be guilt outside of the law. Even Scripture says that. So if government's not following the procedures and processes, the agreed upon code of conduct established by the majority, if they're not fulfilling the obligations that they have and obeying the law, then everything that they're doing is unlawful, which means everything it produces is unlawful. And that's why this is such a big deal, you guys. What we have here is fucking huge. Because when the Supreme Court of the United States comes out in 1833 through the Marshall Court and the despicable shit that he said, where he said we're going to suspend the Constitution, we're not going to give the people the rights that they're guaranteed. In 1833, he did that because he wanted to pave the way for the first national bank, because that's what that was about. In August, they established the first national bank. And the reason why they needed Barron v. Baltimore ruled that way was because they knew that the states were going to sue. And if the states sued, right, they were going to win because they were going to sue the central government. We didn't want a debt-based system. We didn't want the banks. We didn't want them. That's why we destroyed them, right? We're on our third one now. And look what's done to us. It's chained us to financial institutions and foreign corporations. But nonetheless, they won it. These judges and they're all just bankers. We know that. Commercial system. So to have standing in federal court, you must, one, be people, right? Or an aggregate of the people. In the case of the state that would be suing the central government. And two, you must be directly impacted by the law. So in Barron v. Baltimore, what they said was, oh, no, that's not a restriction against the states. It's only a restriction against the central government. And so what they said there was, Constitution doesn't apply to you, states. You don't have standing in federal court. You can't sue when we put into place this national bank. And that's what they did. They established the national bank in August. And then the states tried to sue. And they said, oh, no, Constitution doesn't apply to you guys. Barron v. Baltimore. Constitution doesn't apply to you. You're not directly impacted by the law. Therefore, you have no grounds for suing. You have no claim in federal court. That's why they did it. Now let me tell you right now that ruling is still standing Supreme Court precedent today. That's the reason why you don't get an indictment by a grand jury. Because that court has never stepped up and corrected the unlawful, unconstitutional, despicable statements and rulings of their predecessors. When Marshall denies the people of the United States the rights that they're guaranteed by failing to obey the Constitution and its supremacy, and just simply suspends statutory obligations, suspends the Constitution, and we live today in a state of suspended of laws, right? That's what martial law is, guys. Where do you think that word came from? Martial law. Martial law is about suspending statutory obligations. You suspend the Constitution. That theory came from Marshall, Chief Justice Marshall. It's the Marshall Court created martial law, and he created the U.S. Marshals. The reason why the U.S. Marshals is unconstitutional is because they are a law enforcement branch of government that works for the judicial branch. How can the judicial branch enforce the law? You can't have them under the authority of the judicial branch because they don't have the authority to enforce. But now you have an agency that's working for the judges and going out and doing the beck and call of the judges, committing all kinds of constitutional violations because they're enforcing the laws of the judicial branch. And once again, that's an overstepping separation of powers as well. This judicial branch is out of control. They've stepped in and they've decided that they can do all this stuff, guys. They can legislate by creating rulings. They can amend the Constitution of the United States by their judicial ruling, such as they did in Hurtado versus California, such as they did in Barron versus Baltimore, such as they did in Santa Clara County versus Southern Pacific Railroad, such as they did in Hans versus Louisiana, and on and on and on. They have a long history of misreading the law intentionally in order to advance their industry and cover up the illegal acts that they've been committing. This court does not want you guys to know the truth. They don't want the people to know the truth. They know the truth. They know it. That's why they're ignoring it. They know it. That's why I'm still alive. Because they know that if they came after me, it's just going to draw attention to this issue. And they can't have that. That's the last thing they want. I can say whatever I want to say, and as long as I'm talking the truth, they can't do a damn thing to me. They have to ignore me because they can't call attention to this issue. If they did anything to me, that would call attention to it. And by that attention, that would be maybe even enough to get the country talking about this issue. Because this is so simple and straightforward, you guys. Simple. Two issues that we want the Supreme Court of the United States to address. One, do states have the authority to enact their own alternative legislation and substitute it for the provisions and guarantees of the Constitution of the United States of America? Do states have the right to enact their own law and replace that law with the Constitution? Absolutely fucking not. That's a rhetorical question. Doesn't even need to be answered, but you know what? Apparently this government is too fucking closed-minded or stupid or fucking, they've missed their civics classes to understand that no, states do not get to fucking create their own law and then go and enforce that in violation of the Constitution of the United States of America. We know that, guys. We know that. But they apparently don't know that. Because they say, oh, that's states' rights. States have the right to be able to enact their own laws, replace them with the provisions and guarantees of the Constitution because it's the states' rights. I have a recording from senators saying that shit to me. United States senators that are unwilling to defend Article 1, unwilling to defend their own constituted duty because no one else can amend the Constitution but the legislature. And if they are stepping up and saying, oh, yeah, states can do that. They can amend the Constitution. Guess what? Mark Lane, you're fucking done. There is no senator of Oklahoma because you just ceded your authority and your power to the states, right? If you're going to permit the states to overstep the separation of powers and do your job, and you're unwilling to stand up and defend your job, you have no job. That means that the states are more powerful than you are. You're just a fucking pussy. Every one of them are, because y'all know about it. Y'all know about it. So Barron versus Baltimore. Marshall puts into place this ruling. Says, yep, you don't get the Bill of Rights. So then from 1833, when Barron versus Baltimore was put in place, they put it in place the First National Bank. It operates for a little while before President Jackson, demolishes it, gets rid of it. And then we end up with another one down the road. But nonetheless, what happens then is that from 1833 until 1925, no one is protected by any of the guarantees of the Bill of Rights. Freedom of speech, freedom of press, indictment by grand jury, right to confront your accuser, cruel and unusual punishment, all these things that you believe that you have because you can read the goddamn Constitution yourself and you can see that it says right there. For some reason, we didn't get those. For some reason. And you fast forward to 1925. Then 1925 happens, and now a case called Gitlow versus New York comes forward. Gitlow versus New York. And in that particular ruling at the United States Supreme Court, they said that the freedom of speech is protected against interference by the states because it's codified in the Constitution's text. So the freedom of speech is protected against interference because it's codified in the Constitution's text. Great. We have it because it's written in the Constitution. But wait a second, did we have that in 1776 when we declared our freedom to speak? Or didn't we have that in 1787 when we adopted and ratified the Constitution of the United States of America with the Bill of Rights? Seems to me like we would have always had it, right? Why is it in 1925 the Supreme Court's having to come out and say, oh yeah, you got the freedom of speech? Okay, what about the other ones? What about the right to confront your accuser? Do you have that? Oh no, you only have freedom of speech in 1925. That's all. You only get that. You don't get all of them, even though all of them are written and enumerated in the Constitution. You only get that one. See, this is when they started what was called the incorporation doctrine. Okay, I'll hit the where to send the affidavits in a moment because we're going to talk about that because I don't know quite yet. Every single post office is refusing to send or refusing to deliver. Guys, they're doing that as another diversion to try to break up, in here. They're trying to damage my credibility, and that's okay. And I'm going to tell you why in a moment. We'll come back to that, all right? I want to finish this incorporation doctrine because I've been trying to get this across to everybody. So 1925, Gitlow versus New York says that you have the freedom to speak, and that's protected. States can't interfere with your freedom to speak. But that started the incorporation doctrine. And the incorporation doctrine was one at a time, as cases came forward, they would hear the case that was related to one of the provisions of the Constitution or the Bill of Rights, and then they would side to incorporate it. So for instance, 1958, Miranda versus Arizona, your right to not self-incriminate. No person shall be compelled in any criminal case to act as a witness against himself. Miranda came forward and said, hey, man, I was compelled to act as a witness against myself because of the threats, coercion, duress that the police were giving me. The Supreme Court said, oh, yeah, you can't do that because that's codified in the Constitution. It's enumerated. Now, all of a sudden, we are guaranteed our right to not be able to self-incriminate, forced into, compelled through threats and intimidation. Great, okay. Then 1969, Duncan versus Louisiana. Duncan versus Louisiana was the right to a trial by jury. Right? Duncan came forward and said, hey, man, they're telling me I don't get a trial by jury, but it says it right here in the Constitution I do. So he brought it to Supreme Court. Asked the Supreme Court, do I get trial by jury? It says it right here, I do. Supreme Court said, yeah, you do. It's right there, you get it. It's incorporated. The last provision to have been incorporated was in 2019. And it was the excessive fines clause of the 8th Amendment. So 2019, we are still incorporating the rights that are written in our fucking face. Right there, we can open up the Constitution and say, why don't I have the freedom of speech? It says right here, I got it. It was incorporated by the Supreme Court in 1925. I got it. Then why am I still being abridged it? So in 2019, Timms versus Indiana comes forward. Says, hey, man, they're trying to give me excessive fines. And is it protected because it says that it is under the 8th Amendment? Supreme Court said, yeah, it is. You're protected. But in their ruling, what they said is they said the privileges and immunities of United States citizens are at a minimum those enumerated within the Bill of Rights, given their legal effect against interference by the states because of their codification in the Constitution's text. Now, the privileges and immunities of United States citizens are at a minimum what is written in the first 10 amendments to the Bill of Rights. At a minimum. That's what you get at a minimum. No one can take them away because those are the privileges and immunities of United States citizens. Protected through the 14th Amendment, which states that no state shall create or enforce any law that shall abridge the privileges and immunities of United States citizens. So when you rely upon the privileges and immunities clause of the 14th Amendment for a corporation, all you got to do is identify any one of the rights that are written and enumerated within the first 10 amendments, and that's at a minimum what you must be given. No state can create or enforce any law that abridges any one of those rights. See, the Supreme Court messed up in 2019. They spoke a little ahead of themselves. But that particular ruling is in our favor because they stated in a unanimous decision with 6 of the judges that we still have on the court right now today that, hey, if it's written in the first 10 amendments, you get it at a minimum. No state can take it away because no state can create or enforce any law that shall abridge the privileges and immunities of United States citizens. The privileges and immunities of United States citizens are at a minimum those enumerated within the Bill of Rights because of their codification in the Constitution's text. My point here is that in 1925, the Supreme Court of the United States started the incorporation doctrine. And they started with the freedom of speech. And they said, yep, it's preserved. You get that because the Constitution guaranteed it. We're obligated to give that to you. And from 1925 until 2025, we still don't have all the rights that are in the Bill of Rights. You know why? Because there's one provision left to be incorporated. One provision left. And that's the grand jury clause of the Fifth Amendment. This is the last one that we have to incorporate. The last one. Every other one has been incorporated. This is the last one. That's what we got to lose right now. Because this court has been trying its damnedest for 243 years to advance their industry of slavery, to preserve and protect their property by removing the guarantees that we have to keep ourselves fucking free. What is the purpose of the Constitution? It is to establish rights and limit powers. People have rights, government has powers. Those powers are specifically limited in order to preserve the individual liberties of the people. But that fucking court from the very beginning said, you know what? If the Constitution got its way, we're all gonna be out of a job. We don't want the Constitution to get its way. And they put into place rulings from the very fucking beginning because they're nothing but a bunch of fucking slave owners, right? And they put into place rulings that were undermining the Constitution and undermining the Union so that they can create hostility, so they can create conflict, so they can create crime because they're fucking criminals. So if our country is being led by criminals, people are acting outside of the law, then that means our country is going to be led toward criminality. And that's going to produce an environment of crime, which is going to produce a society of criminals. We are simply following our leaders, right? That's why crime can't be fought from the bottom up. That's why my church logo is fighting crime from the top down. Because before we can deal with the criminality of people, we must first ensure we got leaders that are going to lead our country in a lawful direction out of love, faith, obedience in the law, and respect for the will of the people. And the obligations that they have, they're delegated by the people. And until we have that, we are not going to be going in a good direction. We cannot produce a good citizenry. And if our country is being led by criminals, then they are acting outside of the law, and there cannot be guilt where there's lawlessness. That's why we can discharge the whole fucking debt. Because you know what? As long as you criminals are leading us, you can't find us guilty of anything. Because where government acts outside of the law, what it produces is unlawful. You can never have an unlawful act or crime committed by government that's going to result in a lawful outcome. Until that Supreme Court of the United States steps up and does the fucking honorable thing and tells the truth about the despicable fucking traitors that have sat on that court, then they themselves are traitors. Because they know about it and they're permitting it to continue by ignoring this. But they're not going to get away from it, right? This is not going to go away. We have the opportunity right now. To hold that court accountable for the disgusting shit that they did to pit the people against each other through racial discourse, through economic discourse. They are creating the conflict so that they can create the crime. They're responsible for it. Because if the Constitution got its way, we would have equal respect for every person. And the reason why violence exists is because people don't respect each other. But if the law is applied equally, we would have peace, we would have harmony. The situations that we're in today are the result of the practices of those that are seeking to dissolute us, right? They're seeking the destruction of us because of the first 28 justices that served on that fucking court 22 of them owned their own slaves, including Chief Justice Marshall. So when Chief Justice Marshall comes out in 1833 and says, yep, I don't want any of my slaves to have any of these rights, so we're not going to give them because the states, as of that moment, they amended the Constitution. They directed every court within the purview of the United States of America that they don't have to follow the Constitution, right? And by the introduction of that fraud that permeated every single court across the country, because all these courts follow the edict of the highest court in the land, when they produced a fraudulent ruling that changed the Constitution in an other than lawful manner, that sent all the states out and all the state courts acting unconstitutionally and denying you your right to confront the hearsay evidence that was against you in a fair and neutral proceeding with a fair and neutral decision maker, also known as a grand jury. You were not being treated as though you were innocent. You're being treated as though you were guilty. Because the right to the presumption of innocence starts with you cannot be held to answer for capital or otherwise if it's a crime unless on presentment or indictment of grand jury. You may not be arrested until the people of the United States has determined that there is sufficient probable cause to assume that crimes have been committed, and that cannot occur until you get the opportunity to tell your side of the fucking story.